think, first of all, good evening to everyone. I'm really thankful to all of you, and especially the youngsters who are here. I hope that was the prodding in the court every time that has ended like this. But I must say one thing before I come to the vote of thanks. Chief, with your permission, the reason why we had conceived this symposium, you must understand this, because you will not understand the reason why our eminent speakers have spoken what they've spoken. What we have seen in practicality, you must understand. Otherwise, you will not be able to implement it. Because what you've heard is very crisp. Every speaker has spoken in their own way. Their experiences over the years crystallized and put into just a few minutes. It takes years and years and years of hard work and labor to reach that stage. What you've heard today, if I may say, are gems from each of the speakers. What you have to understand is, we have experienced, Sister Jyoti, me, Justice Jingan, and all of us who judges who have been in the IPD bench or in the original side. When we have gone through your pleadings, what happens is this. Ordinarily, we have seen, say, 100 pages of suits, if not more, and say almost 120, 130 paragraphs. First question is, why? Is it required? Please go through provision of Order 6. Rule 2, 13, all those are important, but what is the purpose and purport? The purpose is to convey the case, that's all. Not your law, not your sections, not your judgments, not your arguments, and frankly, not your inferences. That so and so has happened, therefore this, no. That you will argue. What's the point of putting all that in the plaint itself? That's why one lady asked question regarding written statement. That written statement is going to be lengthy because your plaints are lengthy, because they are not precise. So why we have come to this is, one, we found your pleadings are extensive, not required. Then reference to law, legal propositions, extracts of judgments. We have seen extracts of judgments in a plaint. Please read Order 6 once again. You are anyway going to argue and give us judgments. Why do you need to put it there? It is not required. That's not a fact, correct? Is the law fact? Is your inferences a fact? Is your argument a fact? None of this is a fact. The fact is what the client has told you, that's all. I have this injury, please get me the relief, that's all. You don't have to say, this judgment said that, Supreme Court said that, Netherlands Court said this. You're not required. Why do you indulge in this? Is one. Then repetitions, as Mr. Anand very crisply put it. Let me put it a little more deeply. You have a synopsis. You put your story there. Thankfully, your synopses are brief, so we're able to read it overnight and try to understand what you are saying. Second, that same thing is found again in brief background of the plaintiff, and the brief background of the dispute, and the brief background of the defendant. Then, of course, you start your plaint, because by that time, plaint has not yet started. So then you start your plaint with the same issue again. You repeat the same thing, right? It may be necessary, certain points, maybe patents or this or that. None of this is beyond CPC. None of this is beyond Order 6. Please understand that. How it affects, you will also understand. I will come to that. Then sections, references are not required. If you are talking about copyright violation, it obviously means some part of it. When you refer to Trademarks Act, obviously it will be 29 or whatever. You may refer to it in a passing phase. That's all that is required. Don't have to quote sections. You may not all be doing it. We are not saying that. We only say, be precise so that it saves time. Now, why we are saying this? Now is the painful part for the judge. You must understand this. There's one overload of unnecessary details. As one of the speakers had said, like I think Ms. Sukumar had said, be critical of your own draft first. Read it and try to understand. If it was you who was sitting as a judge, how would you take it? That's probably one of the best ways of understanding that why you need to be brief and precise and concise. Then repetition of facts, what happens is this. It tends to confuse. You may be clear about your facts because you have drafted it, right? But the court which is sitting there, the judge who is sitting there, hearing it for the first time, may have read through generally, right? But if you have too many facts, when we sit back in our chambers, if we are dictating an order, an ex parte order, we have to sift through maybe 10 times because what you said in para 1 may appear in para 5, maybe appearing in para 20, maybe 100. So when you reach that para 100, you really don't know what it is actually referring to. So you think really that helps the court in passing an order? Ask that question to yourself and see what you answer. That's all I have to say, because you have to understand that part of it, right? It is not the volume, but the value of what you want to put it. So put value in it, not volume. That is the primary difference. Please understand also, as all speakers have said, we have got an unending list, right? Each of us have a different way of dealing with the case. Some are fast, some may not be really fast at all. It is possible, it is human to be like that. But understand one important underlying factor is that judges do get exhausted, right? Like everybody does. So if you have more facts, what will happen is, rather than reaching that core point, you will be going in rounds, you will take the judge in rounds. What does it do? It delays. If you don't understand it today, we'll already say come tomorrow or day after. Where is it leading to? Right? So if you're precise, and you tell us precisely that exactly this is the reason why I have come before you, you will either get it or you will not get it, but that will happen in a jiffy, right? That's what is to be understood by you. And especially youngsters, why we have asked youngsters to come, and having such great eminent speakers sitting here have crystallized their 25, 30, 40 years of life and told you in 2 hours what it should be. Imagine the amount of work they have done. But you have got gems, use them. And have a conscious effort to ensure that your briefs are crisp. And as Mr. Sai Deepak said, that if you have the synopsis, why have the plaint so big? 5 times, 6 times, that's good enough. The same point, you have already crystallized it. And many of you must, who have appeared before me, I can't say about other benches, whenever you ask for me of written notes, I've said not more than 2 pages. And believe me, many of you have actually crystallized in 2 pages. So is that surprising? No, it isn't. It is well within each of you. If you can crystallize your entire arguments of a 100-page plaint in 2 pages, you can crystallize your suits in 15 pages, 20 pages. And like, I agree with Mr. Mehta when he said, some of us who have experienced 30 years back, 20 years back, going to Supreme Court from different cases in SLPs which come from different courts, mofsil courts, subordinate courts in all other parts of the country. 3-page partition suits, and as he said, 2-page, because you are to prove your case in trial by evidence. It's a different thing. The summary applications are different. I'm not on that. I'm only on the primary cause of order 6. Please understand. And arguments, obviously, you please try, as Mr. Anand and everybody else has said, that it should be crisp and precise, and time limitation, I hope we will be able to do that. So that was my 2 bits on it. I hope you are able to understand it, and maybe we'll see a difference in your pleadings now on. Try to crystallize it and limit it to a certain amount. I understand in patent matters and all these matters, you require to put some disclosures, some jurisdiction clause, what about how the patent works? Yes, absolutely. There is no doubt about it. But that same thing can be done in a precise way. If you can put your summary applications in a precise way, so can you do this? That's your undertaking, by basic part of it. With that, I think my issue on this, I don't think so I'll need to go through this, because we'll already spent a lot of time. So I'll just say, Honorable the Chief Justice, Justice Upadhyay Sam, my esteemed brother and sister judges, the eminent members sitting on the bar and on the dais, Mr. Hariharan, and the executive committee members of the Delhi High Court Bar Association, officers of the registry, and youngsters and ladies and gentlemen. I think this was a thought-provoking discussions we've had and the interactive sessions. I will hope, like my sister Justice Jyoti has said, we are hoping that you would have asked questions. So after all, this was a symposium for interactive sessions so that you could learn more. But maybe it will be next time, because we will learn more over the way. I express my gratitude to the Chief Justice, whose gracious presence and invaluable guidance elevated today's deliberations to a meaningful level. The short points I had picked up from each of these speakers, I will just put 2 minutes in that. Honorable Chief Justice, please, each of you, buy this book if you don't have it. Moga's Conveyancing in Pleadings. I think we used to have N.S. Bindra. We used to have N.S. Bindra. Please buy those books. Try to go through them. They themselves very voluminous, of course. But they're trying to give in a voluminous way, a precise way of writing things. Right.
You, Tushar, you please revise it and it will be published again.
I can't do that. I think what Learned Chief has also said is that it ends up in delay of disposals, because the lengthier arguments, obviously the voluminous pleadings, it will create time, it's a time warp. It will create a spinning on its own, which will end up with a long time for a disposal. Second, litigation costs, which are unusually burdened on the plaintiff or the defendant. So obviously this goes without saying. You may be corporate people who are representing, but still cost is a cost, right? And sometimes it may be unnecessary. Then Mr. Anand had very precisely said all the issues about time management, and I hope it's a takeaway for each of you, because I think how to not only precisely and concisely put your pleadings, but to argue it in a very limited manner is most important. You have to understand that. Mr. Sethi's, the best takeaway of Mr. Sethi is the Nariman paragraph. I think that says it all. That sums up Order 6, Nariman principle, and the paragraph. Then honesty of the counsel with all disclosures. Mr. Lal's excellent slides, I must say, must really appreciate. And those we'll be trying to upload it so that you can get the benefit of it more often, because it's practical. Everything has been written practically with judgment so that you understand where it is all coming from. Then Mr. Jayant Mehta's one line which I liked is, a good draft should elicit no or least questions. Do you understand the nuance or the essence of this sentence? That means your pleading is so precise that the bench doesn't need to put questions to you. Okay? Many times you would have found most of us immediately asking the other side, yes, what do you have to say, right? That is a hallmark of a counsel's drafting, and I think it's precisely put by Mr. Mehta in this. And Mr. Sai Krishna, about the emphasis on the sections before you put it in a draft. So please read the sections 10 times if you have to, because every time you'll read a section, you'll find something new. You would have seen so many senior advocates reading the same 29, same 13, same 14, right? Every time it's read. We also read together. We don't say, all right, period, because every time a comma, an apostrophe, or a semicolon, or a colon, or a full stop will and may change the understanding or the interpretation of that section. That's what you have to understand. But you don't need to put it in the pleading. Then prayers has to be extremely precise. We have seen prayers running into 1.5 pages. So we don't know whether it's a prayer or it's a pleading. So please help us in understanding that it is actually a prayer, not a pleading. Okay. Then our Chai Deepak Sahab, I have already said that maximum length multiplied by 5 times of a synopsis, but please don't make synopsis into 25 pages and then justify your pleading of 150 pages. Okay, that's one of the things. Then it's a practical thing he said, speak out your draft. When you speak out your draft, you will hear yourself. When you hear yourself, you'll understand whether you're absurd, whether you are precise and concise, or are you even making sense. That will help you in arguments also, because you will speak only what is relevant and what is required, so you'll write what is relevant. Then of course, one thing, of course, I agree, glorified suits, sometimes reaching to the level of narcissism. I myself and everything about myself, about the company, of course, not you. Maybe that has to be trimmed. I'm not saying it was on a lighter way. Maybe you'll need to trim it to an extent of just making the judge understand this is what I am. Maybe it's not required. Of course, subject to other things, disclosures, non-disclosures, those may be relevant. Then Ms. Swati Sukumar said, criticize your own drafts. That's perfect. Be critical of the result of your suit or your case or an application. Why has it ended like that? Because sometimes in your enthusiasm, as youngsters maybe, you will write more, speak more, do more. Do more is a good part. Speak more may not be. Sometimes you may get caught. So speak only what is required. But that takes training. So be critical and prospective hindsight. I thank each of the members, eminent speakers who have spoken today. I don't know about the youngsters, but I have personally learned a lot, and it's a great thing. And I don't think any one of us in this hall can say that we have reached a pinnacle of knowledge. We haven't. Whatever we may be, we'll still be a learner. We'll always remain a student. We'll always learn from you. Please don't misunderstand that you are youngsters, therefore we don't have to learn from you. There are many times I can personally vouch, I have learned from each of you. All right? It can be so many things. But this is precisely why you must have a nature where the preciseness comes front, other things can take a back seat. Right? I shall fail in my duty if I don't thank the Registrar General, Mr. Arun Bharadwaj, the Registrar Vigilance, Ms. Kaveri Baveja, and Ms. Gitanjali Goyal for doing an excellent job. And of course, the backbone of this entire program, Mr. H.K. Arora, Original Site Registrar, and Mr. Zamir Ahmed Khan, Mr. Arjun Seri from the IT department, have done an excellent job, and all the judicial officers sitting here. Please don't think that I'm not speaking your good name, so you are not part of the team. You are a lot of work you've done, and all my PS, Jyoti's sister, Jyoti's PS, they have done a tremendous job, and we are very, very thankful to you for having this patient hearing from all of us for a change. It's usually the other way around. And I think I can say no more. Please take over. Thank you so much.